Hi guys, I'm Molly with Cash on My Home. In today's video, we're discussing everything probate. Inheriting probate can be a world of emotions, and today we're discussing probate specifically in Tennessee. Probate can often be a significant responsibility left behind by a loved one, and depending on your unique situation, navigating probate can entail various complexities. So today we'll explore what probate entails, how to effectively manage it, and provide you with the invaluable tips to see and ease your journey through this process. So let's dive in. First off, what is probate? Probate is a court-supervised legal process that may be required after someone dies. The probate process in Tennessee involves filing the will, if there is one, with the appropriate court, appointing an executor or an administrator, inventorying and valuing all assets that belong to the person that passed away, paying off debts, paying off taxes, and distributing the remaining assets to the beneficiaries or heirs according to the terms of the will or the state law. Typically, probate grants legal authority to a designated individual, often the surviving spouse or closest relative, to collect the deceased person's assets, to settle the financial obligations, and to facilitate the transfer of the assets to the rightful inheritors. This is all the role of the executor or the administrator. So that sounds like a lot, right? You may be asking yourself, well, how do I know if I have to file probate? And do I even have to file probate if someone's passed away? So how do you know if probate is actually necessary? Not all assets are subject to probate. Only assets solely owned by the deceased person must go through this legal process, while others pass to a new owners without court oversight. Typically, if one of these situations are the case, you may not likely have to file probate. So let's get into it. The first example is a property held in joint tenancy. Assets like homes or bank accounts owned jointly with others automatically transfer to the surviving owners upon death. Property held in tenancy by entirety. Number 2, if real estate is owned jointly with the spouse, the surviving spouse becomes the sole owner upon the other's death. Number 3, assets registered in transfer on death form. Tennessee residents can designate beneficiaries for securities, which then transfer directly to them without the probate process. The fourth case would be living trust assets. Assets held by the trustee of the living trust avoid probate entirely because they are legally owned by the trust itself, not the individual who created the trust. If the property in question is under $50,000 and it is within the state of Tennessee, you may be able to proceed with what we call a simplified probate process, also known as a small estates administration. This process allows for quicker and a less burdensome method of selling the estate compared to the traditional probate proceedings. Now, if none of those apply to your situation or your property, then you may have to file a probate. And you most likely want to get a better understanding of exactly how the process works. So let's break that down in the next section into 8 simple steps. Step 1 would be submitting the will. The executor named in the will starts probate by submitting the original signed will to the county clerk's probate office in the deceased person's county of the residence. If there's no will, a family member or often the surviving spouse or maybe a grown child can petition the court to the appointed as the administrator, and the court issues what we call letters of administration. Issuance of letters, testamentary letters, or letters of administration. Step 2. So once the will is submitted, the court issues letters of testamentary to the executor, granting them authority over the estate's assets. Gaining control of the assets would be step 3. So once that's complete, the executor or the administrator, also known as the personal representative, gains control over the assets that require probate. They typically open an estate estate checkings account and transfer the funds from the deceased person's accounts and utilizes the money to cover the estate expenses. Before opening the account, they must obtain a taxpayer identification number from the IRS. Providing the validity of the will is step 4. If there's a will and its validity must be proven in court. If the will is witnessed by 2 individuals, one of them must testify in court or provide a sworn statement regarding its validity. In case of a contested will, both witnesses must affirm its validity. If the will wasn't witnessed, but it is entirely the deceased person's handwriting, it's considered a holographic will. And you may have heard this term before. A holographic will requiring testimony from 2 witnesses to authenticate the handwriting. Step number 5, notifying the creditors and publishing the notice. The personal representative is responsible for notifying the creditors and publishing of the death in the local newspaper most of the time to allow creditors to make claims. Creditors typically have from 4 to 12 months within the state of Tennessee to submit formal claims, although they may do so informally. Step number 6 would be inventory and notification. Within 60 days of appointment from the court, the personal representative must submit an inventory of probate assets, notify the potential heirs, file a request for release with 10 care if applicable, and then we move on to step 8, distribution of assets. Once debts and taxes are settled, the remaining probate estate is distributed to the rightful heirs. Ancillary probate or out-of-state real estate if the deceased owner is in another state. The personal representative might need to initiate ancillary probate proceedings within the state that that person has passed away or within the state that the property falls in. So now that we've covered that, how long exactly does this entire process take within Tennessee? The duration of probate in Tennessee can vary widely depending on various factors, including but not limited to the complexity of the estate, whether there are disputes amongst the heirs or beneficiaries of the court system, and whether the estate is subject to any challenges or litigation. In straightforward cases with no complication, probate in Tennessee can typically be anywhere between 3 to 6 months and even sometimes up to a year. However, more complex estates or those facing legal challenges could potentially take longer. It's essential to consult with an attorney or familiarize yourself with Tennessee probate laws to get a better understanding of the specific timeline that you may be looking to get yourself into. Now, another common question that I often get is how much does probate actually cost? So the cost of probate in Tennessee can vary, once again, depending on several factors, including the size and complexity of the state, the fees charged by attorneys and other professionals involved in the process, and any court costs or filing fees as well. In general, some common expenses to be expected with probate in Tennessee may include the following: attorney fees. Attorneys typically charge fees for their services, as we all know, in guiding the personal representative through the probate process. These fees can vary depending on factors such as the attorney's experience and the challenges or complexity of the estate itself. Another cost that's often associated are court costs. So there are usually filing fees associated with initiating probate proceedings in Tennessee, as well as potential costs for obtaining certified copies of court documents. Another fee would be executor or administrator fees. The personal representative of the estate, whether the executor, person named in the will, or an administrator appointed by the court, may be entitled to receive compensation for their time and for their effort in managing the estate of this person. This compensation is typically based on a percentage of the estate's value and typically will go to them after the probate has closed. Appraisal and valuation fees are a common one as well. So if the estate includes assets such as real estate or valuable personal property that require an appraisal or valuation, there may be costs for hiring a appraisers, estate sale agencies, or other professionals to help sell some of the items in the house. Other expenses or additional expenses that may come out of the woodworks would be fees for publishing in local newspapers or online newspapers, as well as sending out notices to debtors and creditors as well, or even obtaining tax clearance certifications, which can be a process in its own. So in conclusion, understanding the probate process in Tennessee is crucial for anyone who is tasked to manage an estate for those that may inherit the assets. From the filing of the initial petition to distributing the assets to the beneficiaries, navigating the probate process can be complex, but with the right knowledge and guidance, it can be manageable. Remember, it's essential and highly advised to consult with a probate attorney or an experienced real estate agent in Tennessee that understands probate law and can get you a more accurate estimate of the expenses to be expected and the timeline for that specific property in question. They can provide you guidance on minimizing these expenses and navigating the entire probate process so you don't feel like you're doing it alone. I hope that you found this video helpful. If you are looking for any assistance in selling your probate property, please don't hesitate to reach out to us. We've bought over 250 homes throughout the state of Tennessee and Georgia, as well as Alabama, and many of those homes were going through the probate process. So if we can help you navigate you to the right attorney, real estate agent, or potentially provide you an offer to make that transaction a little bit easier, then give us a call or check out our website. Thank you so much, and we hope you enjoyed this video.